Please be seated. The sitting is open. The court meets this afternoon to hear Spain, Fiji, and the Maldives on the question submitted to it by the United Nations General Assembly. As the delegations are aware, they must keep to the 30-minute speaking time. I shall now give the floor to the President of Spain, Ms. Andrea Gavela Lopez. You have the floor, Madam.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. Spain, pursuant to the invitation by the Court in accordance with Article 66 of its Statute, presented a written statement on the 25th of July 2023. The current oral intervention aims to complete that written statement and furnish the Court with some elements that, from the Spanish point of view, may be of help in discharging the request made by the General Assembly. Spain, in this oral intervention, will amply rely on the advisory opinion rendered on July 9, 2004, on the legal consequences of the construction of the wall in the occupied Palestinian territory. As it is of the view that most of the Court's arguments and replies to be found in this opinion are of paramount relevance and are also applicable to the present case, we are going to address the Court in two main blocks. In the first one, we will briefly analyse the jurisdiction of the Court and then examine the international law applicable to the case, affirming that Israel is bound by this law. In the second one, we will elaborate on the particular issue of international responsibility of states in case of serious breaches of international rules that protect the basic interests of the international community as a whole. The second part will be dealt by Professor Mr. Ripoll Carulla, head of the International Legal Office, while the first part will be dealt by Mr. Emilio Pin, deputy head of that International Legal Office, to whom I kindly invite you to give the floor now. Thank you very much.
I thank Mr. Lopez. I now give the floor to Mr. Emilio Pin. You have the floor, sir.
Mr. President, esteemed members of the Court, it is an honor to speak before this Court on behalf of the Kingdom of Spain. The competence of the Court to give the advisory opinion requested by General Assembly in its Resolution 77/247 is based on Article 65, paragraph 1 of its Statute. The General Assembly, which seeks the advisory opinion, is authorized to do so by Article 96, paragraph 1 of the Charter. The questions are directed to the legal consequences arising from a given factual situation, considering international law. It is indeed a question of legal character. Therefore, Spain is of the view that the Court has jurisdiction to give the advisory opinion requested by Resolution 77/247 of the General Assembly. The lack of consent to the Court's contentious jurisdiction by an interested state has no bearing on the Court's jurisdiction to give an advisory opinion. The goal of the request before the Court is to obtain from it an advisory opinion which the General Assembly deems of assistance to it for the proper exercise of its functions and responsibilities. Mr. President, distinguished members of the Court, both Israel and Palestine are under the obligation to observe the rules of international law. In the 1967 armed conflict, Israeli forces occupied all the territories that had constituted Palestine under the British mandate, including those known as the West Bank, located east of the Green Line. This occupation was immediately and unanimously condemned by Security Council Resolution 242, which underlined that, and I quote, all member states, in accepting the Charter of the United Nations, have undertaken to act in accordance with Article 2 of the Charter, end of quote. The principle of prohibition of the use of armed force is one of the fundamental principles of international law, and as formulated in General Assembly Resolution 2625, is accompanied by the following corollary, I quote, no territorial acquisition resulting from the threat or use of force shall be recognized as legal, end of quote. The Court, which has on several occasions affirmed the importance of this principle, has not hesitated to apply this principle to the Israeli occupation of the Palestinian territories. In the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territories, the Court has recalled the principle of the inadmissibility of the acquisition of territory by war. The Court concluded, and I quote, under customary international law, they were thus occupied territories in which Israel had the status of an occupying power, end of quote. Finally, the Court added, I quote, subsequent developments in these territories have done nothing to alter this situation. All these territories, including East Jerusalem, remain occupied territories, and Israel has continued to have the status of an occupying power, end of quote. Although Israel finally withdrew its civilian and military presence from the Gaza Strip in 2005, it has maintained full control of its borders, coastline and airspace ever since. Consequently, as the Security Council has affirmed, the Gaza Strip constitutes an integral part of the territory occupied in 1967. The Court concluded that Israel's settlement policies in the OPTs, the measures taken with regard to Jerusalem and the construction of the wall, I quote, have been established in violation of international law, end of quote. Not only because they are contrary to the Fourth Geneva Convention, but also because they prevent the exercise by the Palestinian people of their right to self-determination. In its construction, the Court points out that the wall, the temporary nature of which is open to doubt, is accompanied by a regulatory regime aimed at annexing the occupied territories. This aim constitutes a serious violation of the rules of international humanitarian law incumbent upon Israel as the occupying power, has the effect of violating the right to self-determination of the Palestinian people and the human rights of the inhabitants of these territories. These statements are also applicable to the Gaza Strip. Israel's withdrawal from Gaza in 2005 has not meant that the occupation of the territory came to an end, and Israel has retained effective control over the territory through its control of airspace, territorial sea, and external land boundaries. The extensive documentation submitted to this advisory procedure demonstrates that 20 years after the Court's opinion, Israel continues to implement its policies, prolonging the very serious violations of international law found by the Court. Mr. President, distinguished members of the Court, on 3rd October 1991, Israel ratified both the International Covenant on Economic, Social and Cultural Rights and the International Covenant on Civil and Political Rights, as well as the United Nations Convention on the Rights of the Child. As stated by the Court, the protection offered by Human Rights Convention does not cease in case of armed conflict. Regarding the territorial scope of those instruments, they are applicable in respect of acts executed by a state in the exercise of its jurisdiction outside its own territory. That is, that they apply both to territories over which a state party has sovereignty and to those over which that state exercises territorial jurisdiction. Those elements concur in this case. Therefore, Spain considers that those instruments are applicable within the OPTs. As stated by the Court in its advisory opinion of 2004, the territories occupied by Israel have been now, for over 50 years, subject to its territorial jurisdiction as the occupying power. In the exercise of the powers available to it on this basis, Israel is bound by the provisions of human rights law and, furthermore, it is under an obligation not to raise any obstacle to the exercise of such rights in those fields where competence has been transferred to Palestinian authorities. Having determined the applicability of human rights law within the occupied Palestinian territory, it is time to seek whether Israeli policies and practices referred in paragraph 18A of General Assembly Resolution 77/247 have violated those rules and therefore have infringed the human rights of Palestinians living in the territory occupied by Israel. Among those rights that are being violated are those of Articles 17, paragraph 1 and 12, paragraph 1 of the International Covenant on Civil and Political Rights. Also, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967 has underlined in her latest report to the Human Rights Council that Israeli forces often detain individuals without charge or trial in what has been denominated administrative detention. Administrative detention is permissible only under very strict circumstances and must always be carried out in line with the protection afforded under international law. Palestinians in the OPTs are subject to a system of jurisdictional fragmentation in the context of a structure of institutionalized discrimination. Israeli military courts enforce military law upon Palestinians, while Israeli courts apply Israeli civil law to Israelis, including settlers. Regarding the International Covenant on Economic, Social and Cultural Rights, there are several provisions affected by Israel's policies and practices in the OPTs. For example, the right to work, protection and assistance accorded to the family and to children and young persons, the right to an adequate standard of living, including adequate food, clothing and housing, and the right to be free from hunger, the right to health, and the right to education. Similar provisions can be found in Article 14, 16, 27 and 28 of the United Nations Convention on the Rights of the Child. State parties to the Convention on the Rights of the Child, according to its Article 2, shall respect and ensure the rights set forth in it to each child within their jurisdiction. Of particular concern are the detention, interrogation, prosecution and imprisonment of numerous Palestinian children by Israeli occupation forces, practice that is contrary to Article 37, paragraph B of that convention. Certain policies and practices of Israel in the OPTs impose restrictions on the freedom of movement of the inhabitants of the OPTs and deprive a significant number of Palestinians of their freedom to choose their residence, and have, as well, repercussions for agricultural production through the confiscation and destruction of agricultural assets. On the other hand, the population of the OPTs is experiencing increasing difficulties regarding access to health services, educational facilities, and sources of water, impeding the exercise by the persons concerned of the right to health, to education, to water, to sanitation, and to an adequate standard of living. All these difficulties and restrictions infringe a number of rights of Palestinians residing in the territory occupied by Israel, which cannot be justified neither by military exigencies nor by the requirements of national security or public order. Mr. President, distinguished members of the Court, the International Law Commission, in the report of its 73rd session, has referred to the basic rules of international humanitarian law as having the status of a peremptory norm of general international law, jus cogens, with the legal consequences that that status may entail. The provisions of the Hague Regulations, annexed to the Fourth Hague Convention of 1907, to which Israel is not a party, have become, nevertheless, part of customary international law. Particularly pertinent in the present case is Section 3 of those regulations, which concerns military authority over the territory of the hostile state. Furthermore, the Fourth Geneva Convention, to which Israel is a party, is applicable in any occupied territory in the event of an armed conflict, and, as the Court has assessed, it is applicable to the territories occupied by Israel since 1967, including East Jerusalem. Regarding Israeli settlements, Article 49, paragraph 6 of the Fourth Geneva Convention provides that, I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies," end of quote. It prohibits also any measure taken by an occupying power in order to organize or encourage transfer of parts of its own population into the occupied territory. Since 1977, Israel has conducted a policy and developed practices involving the establishment of settlements in the OPTs, which are in contravention of the aforementioned Article 49, paragraph 6. Therefore, the Israeli settlements in the OPTs, including East Jerusalem, have no legal validity and constitute a flagrant violation of international law and a major obstacle to the achievement of the two-state solution, as stated repeatedly by relevant UN Security Council resolutions. The establishment of the Israeli settlements in the OPTs is tending to alter the demographic composition of that territory, contributing to demographic changes, all in contravention of Article 49, paragraph 6 of the Fourth Geneva Convention. The practice of demolitions results in the forcible transfer or forced eviction of Palestinians and impedes a de facto return of Palestinian families and communities to their original dwellings, all in contravention of international humanitarian law. Furthermore, in 2004, the Court considered that the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case it would be tantamount to a de facto annexation, as well as a contribution to further alterations of the demographic compositions of the OPTs. Articles 47, 49, 52, 53 and 59 of the Fourth Geneva Convention remain applicable to the OPTs and are to be taken into account in this case. Spain is of the view that neither Article 51 of the United Nations Charter nor the state of necessity have any relevance in this case in order to preclude the wrongfulness of those actions. Mr. President, let me now invite you to give the floor to Professor Santiago Ripoll, Head of the International Legal Office.
I thank Mr. Pinn, and I'll give the floor to Professor Ripoll. You have the floor, Professor.
Mr. President, distinguished members of the Court, what are the legal consequences arising from the repeated, permanent and aggravated non-compliance of core rules of international law? This is the question the General Assembly requested to the Court. When this question is examined from the perspective of the law of state responsibility, the importance of the advisory opinion becomes critical. Articles 40 and 41 of the 2001 draft articles on responsibility of states for internationally wrongful acts answer this question. According to these articles, a serious breach of an obligation established for the protection of the interest of the international community as a whole entails the legal consequences stipulated for all breaches of international law, and some particular consequences. Therefore, the responsible state is obliged to cease the wrongful act, to give, if appropriate, guarantees and assurances of non-repetition, and to make reparation. Moreover, the responsible state is bound to continue performance of the international obligation. On the other hand, failure to comply with international obligations gives also rise to the right for the injured state to seek redress or take countermeasures. However, it has been said, Article 41 states that besides these ordinary consequences, serious breaches of jus cogens rules gives rise to some additional particular consequences, which, generally speaking, imply certain obligations for all other states to respond to the wrongful act, namely, obligation to cooperate with and bring to an end the alleged violation, obligation not to recognize the legal situation, and obligation not to render aid or assistance in maintaining the situation. Mr. President, my intervention will focus on these particular obligations of all states, other than the injured states. In its 2004 advisory opinion on the war, the Court briefly referred to these additional consequences. 20 years later, with the worsening of the situation in the occupied Palestinian territories, the Court is called upon to set out in greater detail these obligations. Mr. President, distinguished members of the Court, the duty to cooperate to bring to an end remains the first obligation of the states, according to Article 41 of the draft articles. This obligation to cooperate shall be carried out by all states. In the Israeli-Palestinian conflict, cooperation among all states has been organized in the framework of the United Nations. Once again, 20 years after the advisory opinion on the wall was passed, it is an indisputable reality that the situation in Palestine has worsened and that resolutions of the Security Council and the General Assembly have repeatedly condemned the actions of the parties and repeatedly demanded the cessation of the violations of international law. However, such resolutions have failed to establish redress and sanction measures. Therefore, the reference of Article 41 to the action of all states becomes critical. In some way, paragraph 159 of the advisory opinion on the wall underlines this when this paragraph established that it is also for all states to take measures to end the breach. Moreover, in the comments to conclusion 19 of the draft conclusion on identification and legal consequences of parental norms of general international law, jus cogens, we can read that this statement suggests that over and above collective action, there is an obligation on individual states to make efforts to bring situations created by the breach to an end. In the current circumstances, maybe the Court could determine what such an obligation to cooperate might consist of in this case. In doing so, the Court may take into consideration the numerous resolutions of the Security Council and the General Assembly, especially those resolutions stating that states are obliged not to take measures that would imply changes in the status of the occupied territories, including East Jerusalem and the Gaza Strip. Corollary is clear. Establishing diplomatic missions in the Holy City is a serious threat to the stability of peace in the region and the world. Coming back to the cooperation of all the states within the bodies of the United Nations, the Court could determine whether the obligation of all states to cooperate to bring to an end any serious violations of parental norms entails the duty within the Security Council, in particular, entails the duty to not prevent, hinder, or delay collective action in favour of the peaceful resolution of the conflict. Mr. President, let me move on now to consider the two particular duties included in Article 41, paragraph 2 of the 2001 draft articles, namely the duty not to recognise the legal situation and the duty not to render aid or assistance in maintaining this situation. What situation? The last resolutions adopted by the Security Council and the General Assembly on the Israeli-Palestinian conflict update the scope of the current situation that should not be legally recognised. Certainly, Resolution 7488 of the General Assembly, the first one including this formula, calls upon all states not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, including those aimed at advancing annexation in the occupied Palestinian territory. Since these two obligations have been reiterated by the Court and other United Nations bodies in this, but also in other situations, they are to be considered as customary law, something that, by the way, the International Law Commission has already affirmed. Finally, let me, Mr. President, to refer briefly to paragraph 3 of Article 41 of the draft articles, which states that international law may recognise additional legal consequences deriving from the legal regime to which the primary rule that has been violated belongs. These particular obligations can be found either in the foundation of the legal regime in particular or the Security Council resolutions. Article 47 and 146 of the Fourth Geneva Convention are good examples of obligations provided for in the foundational treatise of a concrete, a particular legal regime like international humanitarian law. While Article 47 establishes the inviolability of the rights of persons in occupied territories, Article 146 refers to the obligation of the states parties to the Convention to prosecute and condemn persons who commit or ordered to be committed any of the grave breaches of the Geneva Convention. As said, sometimes these obligations linked to a particular legal regime sometimes are specified by the Security Council itself. This is the case of Resolution 2334 of 2016, which requires the states to distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. Mr. President, distinguished members of the Court, Spain formulates these considerations within the framework of a consultative procedure, aware that the Court, guardian of international legality, can offer the United Nations arguments to adopt decisions to address the situation and, at the same time, contribute to the clarification and development of the international legal order. Thank you very much.
I thank the delegation of Spain for its presentation. I invite the next participating delegation, Fiji, to address the court and call upon Mr. Filippo Tarakinikini to take the floor.
Mr. President and esteemed members of the International Court of Justice, it is my great honor to appear before you today on behalf of the Republic of Fiji. Mr. President, for many decades, Fiji has built a tradition of peacekeeping. Our commitment to world peace is unwavering, and we are resolute in our efforts to contribute to global stability. I have personally had the privilege of leading peacekeeping operations in the Middle East over a period of more than 20 years. Mr. President, members of the Court, Fiji supports all efforts to establish a comprehensive, just, and lasting peace for both Israelis and Palestinians. Efforts that recognize the right of Palestinian people to self-determination and the right of the Jewish state of Israel to exist as a sovereign state with secure borders. Efforts that emphasize the need for the parties to engage in constructive negotiations as envisioned by the Security Council and the General Assembly. Fiji affirms the important role of this court as the highest judicial organ of the United Nations in resolving disputes between states and assisting UN organs in their activities. In so doing, the court must promote the purposes and principles of the United Nations Charter. According to Article 1 of the UN Charter, one of the main purposes of the United Nations is, and I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, end of quote. Fiji strongly believes that the only way to achieve truly sustainable peace between Israel and the Palestinian people, indeed between any neighbors, is through mutual respect. As reflected in our written statement, Fiji considers it essential to maintain and uphold the legal framework agreed between the parties and sanctioned by the Security Council to resolve the Israeli-Palestinian dispute. That framework is founded on the understanding that Jews and Arabs must coexist in a small piece of territory. This requires direct negotiations between the parties for an agreed outcome. Mr. President, members of the Court, the General Assembly has requested the Court to answer certain questions that focus on the legal consequences of the policies and practices of only one party to this dispute. To answer these questions, the Court would need to carry out an independent judicial assessment of both the law and the facts on virtually every aspect of the Israel-Palestine dispute, taking account of the relevant context. This is not an easy task. As Judge Higgins noted in her separate opinion in the Wall Advisory Opinion, and I quote, the law, history, and politics of the Israel-Palestine dispute is immensely complex, end of quote. Further, context is usually important in legal determinations. In Fiji's view, this court has unfortunately been presented in these proceedings with a distinctly one-sided narrative. This fails to take account of the complexity of this dispute and misrepresents the legal, historical, and political context. In its written statement, Fiji has provided several reasons why the court should exercise its judicial discretion not to render an advisory opinion on the questions that have been posed by the General Assembly. First, the request is a legal maneuver to circumvent the existing internationally sanctioned and legally binding framework for resolution of the Israel-Palestine dispute. Second, to give an opinion in this case, and I quote, would have the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent, end of quote. And third, due to the one-sided formulation of the questions posed in Resolution 77/247, the court does not have before it the accurate and reliable information that it would need to render an opinion on the questions posed. Mr. President, members of the court, in this oral presentation, I will address the first and third of these issues. I turn to the existing framework. In these proceedings, the court has been asked to render an advisory opinion that may well mean, in effect, the immediate, unconditional, and total end to the occupation. That is, withdrawal of all Israeli military, civilians from the entirety of the West Bank, East Jerusalem, and Gaza. This withdrawal must not only be complete, but it must also be unconditional. In other words, Israel may not impose or require any limitations or conditions. This unconditionality is supposedly necessary in order that the Palestinian people have a sovereign state on such territory, which they assert is the only way to achieve justice and therefore peace. Fiji respectfully submits that this demand of a complete and unconditional withdrawal circumvents the peace process and the agreements that have been made in pursuit of that process. Mr. President, the fact is that from 1993, Israel and Palestine entered into the series of agreements known collectively as the Oslo Accords. The parties expressed the intention to, and I quote, put an end to decades of confrontation and to live in peaceful coexistence, mutual dignity and security, while recognizing their mutual legitimate and political rights, end of quote. To that end, they agreed on a wide range of interim measures pending the achievement of a final agreement through permanent status negotiations. Some of those interim measures include the Palestinian Authority was established. Powers and responsibilities were transferred from the Israeli military government and its civilian administration to the Palestinian Authority, while Israel continued to exercise powers and responsibilities not so transferred. Direct, free, and general political elections were to be held by the Palestinians. The West Bank was divided into 3 areas, A, B, and C. The Palestinians would obtain exclusive control over Area A. Area B would be under joint Israeli-Palestinian control, and Area C would be under exclusive Israeli control. Lastly, the parties would enter negotiations on the permanent status to resolve the remaining issues, which included settlements, borders, Jerusalem, and security. In addition, the Oslo Accords contain a specific dispute resolution mechanism and do not permit either party unilaterally to commence or ask others to commence external legal proceedings. Since 1993, an extensive set of arrangements have been put in place to operationalize the agreements. In 2003, the General Assembly endorsed the Oslo Accords, and the Security Council has, and I quote, endorsed the Quartet performance-based roadmap to a permanent two-state solution to the Israeli-Palestinian conflict, end of quote. This court itself confirmed the importance of the Oslo Accords and the roadmap in the Wall Advisory Opinion in 2004. According to the roadmap, and I again quote, a two-state solution to the Israeli-Palestinian conflict will only be achieved through an end to the violence and terrorism. When the Palestinian people have a leadership acting decisively against terror and willing and able to build a practicing democracy based on tolerance and liberty, and through Israel's readiness to do what is necessary for a democratic Palestinian state to be established, and a clear, unambiguous acceptance by both parties of the goal of a negotiated settlement, end of quote. The thrust of the Oslo Accords and the roadmap is mutual performance and good faith negotiation leading to a consensual outcome. The Oslo Accords are legally binding. Remarkably, the Palestinians do not refer to these agreements in their written statement, while less than 12 months ago, both Israel and the Palestinians reaffirmed their, and I quote again, unwavering commitment to all the previous agreements between them, and to address all outstanding issues through direct dialogue, end of quote. Mr. President, it is our submission that the request to this court to opine on questions that address the legal obligations of only one party to this dispute conflicts with the clear rights and obligations of both parties in the Oslo Accords and the roadmap, and which exclude recourse to this court. For this reason, Fiji respectfully submits that the court should exercise its discretion not to render an opinion on those questions. Mr. President, members of this honorable court, I now turn to the issue of legal and factual evidence. As stated, in Fiji's view, the court should decline to answer the questions posed. But were it to do so, it would need to gather and independently assess the probative value of evidence on issues raised within the established legal framework of the dispute. This court would have to decide, as it has previously explained, and I quote, whether it has before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon any disputed questions of fact, the determination of which is necessary for it to give an opinion in conditions compatible with its judicial character, end of quote. In Fiji's view, the court cannot simply defer to the reports of United Nations bodies. In order to fulfill its judicial function, the court must reach its own independent findings of fact. Further, Fiji submits that due to the selective and one-sided formulations of the questions, the court does not have before it all the evidence it would need to exercise its judicial function. Mr. President and members of the esteemed members of the court, the point here is that the court is being asked to focus solely on the policies and practices of one of the parties to this dispute, to the exclusion of the policies and practices of the other. This is highly problematic. If the court would limit itself to consideration of the questions asked, it would be unable to consider the relevant broader context and it will also not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion upon questions of fact that are in dispute, all of which would be necessary to give an opinion compatible with its judicial character. We will illustrate this by looking briefly at three of the issues raised by the questions that have been posed to the court. And these are withdrawal and security, territorial sovereignty, and the right to self-determination. First, withdrawal and security. Palestine argues that the occupation is illegal, and the legal consequence is that Israel must withdraw from the occupied territories. As highlighted earlier, any assessment of the questions posed would require the court to consider the legal rights and obligations of both parties under the Oslo Accords. The Oslo Accords were built upon Security Council Resolution 242 and 338, which were adopted following the 1967 and 1973 Arab-Israeli wars. They recognized the legitimate security needs of Israel to prevent further attack. Resolution 242 and 338, and thus the Oslo Accords, do not oblige Israel to withdraw from all the territories. Further, Resolution 242 and 338 refer to peace being established by the application of two mutually dependent principles, and I quote, first, withdrawal of Israeli armed forces from the territories occupied in the recent conflict, and two, termination of all claims or states of belligerency and respect for and acknowledgement of the sovereignty, territorial integrity, and political independence of every state in the area, and their right to live in peace within secure and recognized boundaries, free from threats or acts of force. End of quote. By incorporating these resolutions into the Oslo Accords, the parties recognize that Israel's withdrawal and the creation of conditions providing security to Israel are interdependent. As Judge Higgins stated in the Wall opinion, both, and I quote, Israel and Palestine need to move in parallel to secure the necessary conditions for Israel to withdraw from Arab-occupied territory and for Palestine to provide the conditions to allow Israel to feel secure in so doing. End of quote. In other words, if the court is to consider the legal consequences of the alleged Israeli refusal to withdraw from territory, it should also look at what Palestine must do to ensure Israel's security. Mr. President and members of this honorable court, the events of 7 October 2023 have shown us what could happen if there were a complete and unconditional withdrawal without the necessary arrangements in place to guarantee the security of Israel and its population. At the very least, the court would need to examine and evaluate. This in turn would require examination of the threats facing Israel, emanating from the occupied territories and the broader region. Second, territorial sovereignty. Mr. President and members of the court, the General Assembly's request speaks of Israel's, and I quote, prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, end of quote. This asks the court to presuppose that all the territories held during the Jordanian and Egyptian occupation within the 1949 armistice lines are Palestinian. That is, that they are sovereign territories of Palestine and thus not of Israel. A precise definition of the scope of territorial claims is important because, and I quote, territorial sovereignty is a fundamental principle of the international political and legal order. It serves to divide between nations the space upon which human activities are employed in order to assure them at all points the minimum of protection of which international law is the guardian. End of quote. In the context of the questions put to this court, territorial sovereignty is critical because without clarifying the respective claims of Israel and the Palestinians concerning the sovereign status of the territory it would be impossible to answer the questions of territorial scope of the Palestinian self-determination claim or the occupation. Fiji notes that the question of territorial scope, both of the State of Israel and of the self-determination claim of the Palestinian people, is in dispute between the parties. And yet, the way the questions are drafted excludes the possibility of the court considering Israel's claims to the sovereignty over the territory and asks the court to assume, without further investigation, that these territories are somehow Palestinian. Furthermore, the court would need to assess whether the Palestinians have sovereignty, and if so, over which territory. This would include an examination, among other things, of the history of the Palestinian assertions of claims and of whether Palestinians make different assertions of sovereignty in different fora. Palestine asserts that the provisions in the mandate for Palestine concerning the establishment of a Jewish homeland as envisaged in the Balfour Declaration were illegitimate and in contravention of the Covenant of the League of Nations. It appears to claim that all the territory of Mandate Palestine, even including what is generally accepted to be the territory of the State of Israel, belongs to the Palestinian people. Mr. President, Israel asserts, and Fiji agrees, that the mandate for Palestine, including its provisions concerning the establishment of the Jewish homeland, such as the right of the Jewish people to live in and closely settle the land, was a binding instrument of international law. Israel also argues that the relevance of the rights conferred by the mandate for Palestine was affirmed in Article 80 of the UN Charter, the so-called Palestinian Clause. There is thus a dispute about territorial sovereignty. Fiji submits that this dispute cannot and should not be resolved through means of the requested advisory opinion for two reasons. The first reason is that the question of borders and therefore the scope of territorial sovereignty was expressly agreed to be resolved through the permanent status negotiations to which the parties have committed themselves in the Oslo Accords. For the reasons set out earlier, this precludes the matter being adjudicated via an advisory opinion procedure. The second reason is that, in any event, because of the way the questions to the court have been formulated, the court simply does not have before it sufficient information and evidence to enable it to arrive at a judicial conclusion on the disputed issue of the geographic limits of the territorial sovereignty of Palestine and Israel. I now turn to self-determination. The questions before the court ask it to assume that Israel is violating the right of the Palestinian people to self-determination. The question of self-determination raises the question of territorial scope. This raises the evidentiary concerns I have just expressed. Moreover, Fiji notes that the right to self-determination is a relative right. It should not involve changes to existing frontiers. In the context of Israel-Palestine, this means that the court would need to ascertain whether the Palestinians' exercise of their right to self-determination has infringed the territorial integrity, political inviolability, or legitimate security needs of the State of Israel. By asking the court to look only at the policies and practices of Israel, Resolution 77/247 shields from the court's purview the policies and practices of Palestine. The result in Fiji's submission is that the court simply does not have before it sufficient information concerning the policies and practices of Palestine, and thus is unable to make a judicial determination on whether, in exercise of their right to self-determination, Palestine has infringed the sovereignty of the State of Israel. Mr. President, esteemed members of the court, in conclusion, the relationship between Israel and the Palestinian people is legally, factually, and historically complex. There are no simple answers. But there are two parties who need to jointly find a solution, and they should be supported to do this. Using the advisory opinion procedure to prosecute the alleged violation of international law of one of the parties to the dispute while ignoring possible violations by the other will not promote dialogue nor foster mutual respect. Rather, it is likely to undermine efforts towards peace that can be best settled through the recommitment of the parties to the processes established under the Oslo Accords. In our view, this is why the General Assembly was seriously divided on whether this question should be put to the court for an advisory opinion. And it is also why this honourable court should refrain from giving one. Fiji respectfully submits that for all these reasons, the court should exercise its judicial discretion to decline to provide an advisory opinion on the specific question put to it in the UN General Assembly Resolution 77/247. Mr. President, were the court to decide to provide an advisory opinion, which Fiji submits it should not, the court should be cautious to ensure the advisory opinion rendered does not circumvent the binding agreements between the parties, but encourages them to promote fruitful negotiations. Furthermore, the court should ensure that it does not impose obligations and responsibilities on only one party while disregarding its legitimate concerns. Mr. President, members of this honourable court, this brings me to the end of Fiji's oral presentation, and I thank you.
I thank the delegation of Fiji for its presentation. I now call upon the delegation of the Maldives to address the court and invite Her Excellency Ms. Shakir to take the floor.
Mr. President, members of the court, I have the honor to appear before you on behalf of the Republic of Maldives, a state staunchly committed in upholding international law. Support for the Palestinian people, including their pursuit of an independent sovereign state of Palestine, has been a long-standing cornerstone of the Maldives foreign policy and remains so under the government of President His Excellency Dr. Mohamed Muizzu, who took office in November 2023. There are no compelling reasons not to exercise jurisdiction. To the contrary, the dire humanitarian crisis unfolding in Gaza reminds us all that this is a historic opportunity for the court to pronounce its verdict on the grave injustices that have been long perpetrated against the Palestinian people. The Maldives oral submissions today will come in two parts. Ms. Amy Sander will first address the court on Israel's multiple serious violations of international law in the occupied Palestinian territory, focusing on its practices in relation to water resources. Following this, Dr. Naomi Hart will provide concise answers to the two questions which the General Assembly has requested that the court answer. Before concluding, I would like to once again reiterate our firm belief that the only sustainable solution to the conflict is the establishment of a sovereign and independent state of Palestine based on the pre-1967 borders with East Jerusalem as its capital. Mr. President, members of the court, I thank you for your attention and ask that you give the floor to Ms. Sanders.
I thank Her Excellency Ms. Shakir. I now give the floor to Ms. Amy Sander. You have the floor, Madam.
Mr. President, members of the court, representing the final state appearing, I have the honour of identifying the main points addressed during the course of this hearing on the violations by Israel of international law. The Maldives provides this analysis with a focus on the issue of water resources. Why? Because of two streams of significance. First, the significance of water resources to the Palestinian people. In fact, it has been described as the most vital resource in the occupied Palestinian territory by Palestine. a tidal wave of suffering has been unleashed by Israeli policies and practices with respect to water resources, which are characterized by deprivation, denial, discrimination and destruction. Deprivation of access to water. Many Palestinians in the Gaza Strip simply have, I use the court's own words, no access to potable water. Denial of enjoyment of those resources on a discriminatory basis. In the West Bank, where Israel has seized control of water resources, use of vital groundwaters is marred by grossly inequitable allocations between Israelis and Palestinians. Destruction of vital infrastructure, with Israel demolishing sanitation structures and pipelines. The second stream of significance is to the questions before the court. The issue of water resources flows through four key aspects of the unlawfulness of Israeli policies and practices on which the oral submissions have focused, and I address each aspect in turn. The first key aspect, the violation of the right of the Palestinian people to self-determination. The following points are crystal clear. First, the Palestinians are a distinct people with a right to self-determination, an inalienable norm of Jus Cogens. Second, Israel's conduct has violated different components of that right, notably the right to territorial integrity, the right not to be subjected to demographic manipulation within that territory by a foreign power, the right of the people to pursue its chosen economic, social and cultural development, and its right to exercise permanent sovereignty over its natural resources. And the critical importance of this well-established latter component, the Palestinian people's right to exercise permanent sovereignty over their natural resources, was recently stressed by the General Assembly in its resolution of December 2023. Such resources clearly include water. Israel's policies and practices with respect to water resources, the deprivation, denial on a discriminatory basis, and destruction, thus constitute one acutely serious and ongoing facet of the breach of the Palestinian people's right to self-determination, described by our UN body as one of the most fundamental conditions for survival. For a people, sufficient clean water is indispensable. Turning to the second key aspect, the policies and practices of Israel in the occupied Palestinian territory violate the prohibition of the acquisition of territory by force. This afternoon, we have heard some attempts to muddy the waters in this regard, so I will recall the points of crystal clarity. First, a corollary of the Jus Cogens prohibition of use of force is the prohibition of any acquisition of territory by threat or use of force, irrespective of international recognition of Palestine's borders. The applicability of this prohibition to the occupied Palestinian territory cannot be in doubt, as expressly recognised in resolutions of both the General Assembly and Security Council. Second, international law requires that occupation be temporary. Third, any purported exercise of the use of self-defence must be necessary and proportionate. Fourth, and flowing from the three previous points, an occupying power cannot acquire sovereignty over an occupied territory, including by annexation, irrespective of whether it claims to have acted in self-defence at any point during the occupation. Yet Israel has annexed all of the occupied Palestinian territory, whether through Israeli law or conduct manifesting a de facto annexation, creating a fait accompli. And there's no shortage of evidence on this reality, as emphasised by many UN bodies and demonstrated by the map recently shown by the Prime Minister of Israel before the General Assembly, referred to on the first day of this hearing. Israel's deprivation, denial on a discriminatory basis, and destruction with respect to water resources is one facet of this annexation. The scale and nature of Israel's conduct in this regard makes clear that it forms an integral element of Israel's establishment of control through coercive measures, reflecting its intention to appropriate that territory permanently. The occupation having, to quote the Special Rapporteur, burst through the restraints of temporariness long ago. Israel's settlement expansion is plainly another integral element of that annexation, with Palestinians reduced to inhabiting a fragmented archipelago of disparate patches of land. Of course, the different aspects of Israel's violations of international law are not watertight from one another. Such prolonged occupation, annexation, and settlement expansion also violate the right of self-determination to which I referred earlier, a right which cannot be exercised in the face of a foreign occupier purporting to appropriate territory for itself and thereby dispossess the Palestinian people. The third key aspect is that the policies and practices of Israel in the occupied Palestinian territory violate the law of occupation. The indisputable starting point is that, as an occupying power, Israel is bound to respect, throughout the occupied territory, its obligations under international humanitarian law, a regime designed to ensure the protection of the people under occupation. And the Maldives agrees that the continuing applicability of international humanitarian law is without prejudice to the unlawfulness of Israel's occupation. Now, many examples of international humanitarian law breaches have been cited before the court, including with respect to Israel's settlement policy as a breach of Article 49 of the Fourth Convention. Israel's policies and practices with respect to water resources constitute a cascade of further violations of the Fourth Geneva Convention and the 1907 Hague Regulations. Notably, Israel's conduct is a violation of the rules prohibiting destruction of property, which includes water and sanitation infrastructure, in circumstances where it is clearly not absolutely necessary for military operations. It's a violation of the prohibition on destruction or removal of objects essential for survival of the civilian population, with water installations and supplies obviously qualifying as such. It's a violation of the prohibition on pillage, as well as the rules of usufruct. It's also a violation of the obligation to ensure and maintain public health and hygiene in territory it occupies. And this goes to a point of grave practical concern. A raft of horrific diseases spring directly from the lack of clean water, with little children particularly vulnerable. The fourth and final key aspect is that Israel's policies and practices in the occupied territory are in violation of international human rights law, including the fundamental Jus Cogens prohibition of discrimination. The irrefutable starting point, this is that Israel bears a duty to secure respect for the applicable rules of international human rights law throughout the territory that it occupies. International human rights law encompasses the right to water. Notably, that right emanates from Articles 11 and 12 of the International Covenant on Economic, Social and Cultural Rights. As the General Assembly affirmed in 2016, the human rights to safe drinking water and sanitation as components of the right to an adequate standard of living are essential for the full enjoyment of the right to life and all human rights. Further, as a party to the Convention on the Rights of the Child, Israel has expressly undertaken to pursue full implementation of each child's rights to the enjoyment of the highest attainable standard of health, including through the provision of clean drinking water. Equally clearly, international human rights law prohibits discrimination. Notably, pursuant to the Convention on the Elimination of All Forms of Discrimination, Israel is obliged to prohibit and to eliminate racial discrimination in all its forms and to guarantee the right of everyone, without distinction as to race, colour, national or ethnic origin, to the enjoyment of rights, which include a right to water. Yet Israel's discriminatory policies and practices with respect to access to water have been well documented and condemned by a deluge of UN bodies, with the Committee on the Elimination of Racial Discrimination, I quote, appalled at the hematic character of the separation of two groups, Jewish communities in illegal settlements on the one hand, Palestinian populations on the other hand, who do not enjoy equal access to water resources. The impact on women and children is notably egregious, with the dearth of clean water an acute crisis for mothers trying to feed their babies. Israel's policies and practices relating to water are but one among many examples of systematic discrimination which have been detailed by other states in these proceedings. And the Maldives joins the plethora of other states in confirming before this court that the regime which Israel has established throughout the occupied territory constitutes apartheid, pursuant to the customary international law definition as reflected in Article 2 of the Apartheid Convention. Mr. President, members of the court, at a human level, Israel's policies and practices with regard to water resources are inexcusably intensifying the hardship being endured by the Palestinian people and exemplify the illegality which has characterized Israel's occupation. The final speech for the Maldives will address how the court should answer the questions posed by the General Assembly in light of Israel's breaches of international law. Mr. President, I thank you for your kind attention, and I invite you to call Dr. Hart to the bar.
I thank Ms. Sander. I now give the floor to Ms. Naomi Hart. You have the floor, madam.
Mr. President, members of the court, against the backdrop of Palestinians' extraordinary human suffering cast in vivid relief this past week, the court's function is to provide advice to the General Assembly on the two legal questions posed to it. It is my honour, on behalf of the Maldives and as the final speaker in these proceedings, to provide succinct, direct responses to those two questions. Question A asks the court to opine on the legal consequences of Israel's ongoing violation of the Palestinian people's right to self-determination, its prolonged occupation, settlement and annexation of the occupied Palestinian territory, and its discriminatory legislation and measures. The states appearing before you have been largely consistent on this question, and that is unsurprising because the relevant principles are well established in the customary international law rules on state responsibility and the court's jurisprudence. First, Israel is obliged to cease its continuing unlawful acts. This includes, of course, an obligation to terminate its occupation, just as South Africa was obliged to withdraw from Namibia, where its presence was illegal. The court there specifically stated that withdrawal must occur immediately. Here, the General Assembly has recently stressed the urgency of achieving without delay an end to the Israeli occupation. But that is not all. Israel must also cease the discrete unlawful practices which have characterised its occupation. For example, it must dismantle the discriminatory regime concerning water resources referred to in Ms. Sanders' speech. In precisely the same way as the court previously stated that Israel must dismantle both the wall and the associated legislative and regulatory regime which entrenched discrimination. Secondly, at the same time as terminating its unlawful acts, Israel must provide assurances that it will not repeat them. Thirdly, Israel is obliged to provide comprehensive reparations. Restitution is optimal as far as possible, but you heard from Palestine last Monday that no action by Israel now could ever restore the Palestinian people to the situation which would have existed without its violations. In that case, Israel's reparations must include compensation. And to the extent that compensation will not fully make good the harms caused, Israel must provide just satisfaction in other forms, such as acknowledging its breaches and providing formal apologies. Fourth, there are obligations on third states. States parties to the Fourth Geneva Convention must search for individuals accused of committing or ordering grave breaches of that instrument and prosecute, including the rules of occupation, and prosecute or extradite them. Further consequences flow from the occupation's unlawful status, and I will deal with those in relation to the second question. In question B, the General Assembly asked the court how Israel's policies and practices in the occupied Palestinian territory affect the legal status of the occupation and what legal consequences arise for all states and the United Nations. Ms. Sander has addressed the many illegal aspects of Israel's occupation. Each and every one of Israel's unlawful acts engages its responsibility as a state. But what is it that determines the status of the occupation? The factors affecting status are those that go beyond illegality in the conduct of the arbitration and that make the occupation irremediable, meaning that the occupation is what the court described in the Namibia opinion as a situation which is maintained in violation of international law. In other words, it is those breaches of international law that cannot be cured within the occupation, but only by the occupation coming to an end, that render it unlawful as a matter of status. One such matter is the permanence of Israel's occupation, notably the fait accompli that this court warned about in its Wall opinion. Israel has sought to create irreversible facts on the ground. As Ms. Sander has highlighted, by installing itself as an interminable presence, Israel has violated the prohibition on acquisition of territory by force. The court need not decide whether Israel's occupation was unlawful ab initio. Its wrongfulness can be established even if one looks only at the fact of its prolonged continuation with no end in contemplation. The wrongful permanence of Israel's presence, that breach all, that is why it goes to the occupation's status. The same is true when it comes to Israel's breaches of the right to self-determination. For example, that right encompasses an entitlement to territorial integrity, whether or not the territory is within the internationally recognised borders, contrary to what you have been told this afternoon. It is inherent in Israel's ongoing occupation that it dispossesses Palestinians of their territory and that it divides the territory. Recall the fragmented archipelago that Ms. Sander referred to. Israel's presence and the Palestinian people's right to territorial integrity are mutually exclusive. And again, this is determinative of the occupation's status. What are the legal consequences of this analysis? For Israel, they include those I have already addressed in relation to question A, starting with the duty immediately to terminate the occupation in its entirety. Given the occupation's unlawful status, Israel simply cannot achieve compliance with international law as long as it remains in occupation. As well, Israel's ongoing presence cannot produce any effects as a matter of international law, and in particular, cannot change the status of any occupied territory. However, as Ms. Sander has alluded to, it is not a consequence of the occupation's status that Israel can somehow escape obligations concerning the conduct of an occupation. To the contrary, pending its urgent withdrawal, Israel remains bound by rules of international humanitarian law. Those rules apply whenever an occupation exists in fact, lawful or not, and as the court has stated, regardless of the status of the occupied territories. The same is true of Israel's obligations under international human rights law. Those duties are engaged based on Israel's exercise of jurisdiction, again, a purely factual state of affairs. The conduct of third states and the United Nations is likely to be of critical practical importance in leading Israel to end its unlawful actions. The people of Palestine, like the people of Namibia half a century ago, should be able to look to the international community for assistance in realising their rights. In light of Israel's gross and systematic breaches of Jus Kogan's norms, third states bear certain negative duties articulated in the court's previous advisory opinions. They must not recognise the situation created by Israel's occupation as lawful or lend that occupation any support or assistance. Accordingly, they must avoid acts which could imply such recognition, such as engaging in trade or any other forms of relationship with Israel which may entrench its position. They also must not enter into or maintain treaty relations in which Israel purports to act on behalf of or concerning that territory, except treaties of a humanitarian character. Third states must not send diplomatic or special missions to Israel with a remit extending to the occupied territory, as if that territory was simply part of Israel. A third state which does not uphold these duties may encounter consequences in its own relations with other states. According to the court in Namibia, no state which enters into relations with South Africa concerning Namibia may expect the United Nations or its members to recognise the validity or effects of such relationship. The same applies here. Equally, third states bear certain positive duties, an obligation to cooperate, including through the United Nations, to complete Israel's extraction from the occupied territory, a duty to remove any impediments to the Palestinian people's exercise of the right to self-determination, and a duty to ensure Israel's compliance with international humanitarian law. As for the United Nations, all of its component parts, but especially the General Assembly and the Security Council, should consider what further action is required to bring to an end the illegal situation. In 2004, the court urged the United Nations, as a matter of urgent necessity, to redouble its efforts to bring the Israeli-Palestinian conflict to a speedy conclusion. That urgency has not abated, it has intensified. How the Court advises the General Assembly on this occasion will, it is to be hoped, help to illuminate the path forward for the entire United Nations system. Mr. President, distinguished members of the Court, that concludes the submissions of the Maldives.
I thank the delegation of the Maldives for its presentation. This presentation concludes the oral statements by all the participants who have expressed a wish to participate in the present oral proceedings. It also brings to a close the hearings on the request for advisory opinion submitted by the General Assembly of the United Nations regarding the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. I would like to convey the Court's thanks to all the delegations who have addressed it in the course of these 6 days, as well as to the participants in the written proceedings. I would also ask the representatives of all participants to remain at the disposal of the Court in case it should require any further information or explanations from them. The Court will now retire for deliberation. The Registrar will, in due course, inform all the participants and all members of the United Nations General Assembly of the date and time when the Court is to render its opinion. As the Court has no other business before it today, I declare this sitting closed.